Good evening, folks, and welcome back to the Shining Light podcast and part 5 of the Goshen School Board 2022 election story. If you tuned into part 4, you know that the 2022 Goshen School Board election was embroiled in controversy when school board members and candidates Alan Kaufman, Jose Elizalde, Roger Nafziger, Mario Garber, and Andrea Johnson put out a mailer attacking their opponents in the race, Rob Rader, Linda Hartman, and Ryan Glick. Following the forwarding of the charges from the election board to the Elkhart County prosecutor, Vicki Becker, which concluded after the last election board meeting in April 2023, months passed with no updates. Then, on February 20th, 2024, news broke that arrest warrants had been issued for the 4 board members and Andrea Johnson, following charges filed against each individual for a level 6 felony count of filing a fraudulent report and a Class B misdemeanor of accepting a contribution made in another's name. Kaufman had 5 counts of the latter item. After being booked and posting bail, the prosecutor offered a deal. What exactly that deal was is not completely clear. 2 of the defendants took a plea deal and pled guilty to the felony charge, though only Elizalde's was immediately available for review. Elizalde's plea stated, the state of Indiana agrees to allow defendant to plead to count 1 filing fraudulent report level 6 felony. Following this, it gave the terms of the guilty plea. Defendant agrees to enter a plea of guilty as set forth above on the following terms and conditions. 365 days Elkhart County Jail, suspended. 365 days reporting probation. 1 weekend of community-oriented work program. Probation to terminate upon completion of the COP weekend. Court costs. By pleading guilty to the more severe charge, the lesser Class B misdemeanor charge would be dropped, and he would avoid prison time. This plea deal made no mention of any agreement to reduce the felony charge to a Class A misdemeanor, but that is what ultimately happened. At sentencing, on August 7th, the judge addressed this discrepancy as reported in the Goshen News. The conviction was entered as a Class A misdemeanor due to his lack of criminal history prior. Elkhart County Superior 3 Court Judge Teresa Cataldo confirmed with the prosecution and Elizalde's defense attorney that, while the plea agreement did not initially allow changes in the sentence, both parties intended to allow the change. The prosecution said they offered misdemeanor status to almost everyone involved in the case, or at the very least to stay silent if it is requested. Glick has since raised concerns about the integrity of the case due to several key issues that trouble him. First, while multiple charges were forwarded to the prosecutor's office, only the charges of filing a fraudulent report and recklessly receiving campaign donations made in another's name were pursued. Although each charge may not have applied to every individual, the limited scope of the prosecution seems excessively lenient given the overall context and severity of the case. Second, the plea deal did not formally include a reduction of the felony charge to a misdemeanor, yet the prosecution extended this leniency to most of the defendants, including Elizalde. This implies that the offer was likely made prior to Elizalde entering his guilty plea. Third, the guilty plea document contains the following signed statements. The motion to withdraw a plea of not guilty and enter plea of guilty and plea agreement and disclosure is entered into as the defendant's free and voluntary act, and that no promises for leniency were made to cause him to enter into this agreement other than those representations made in the motion to withdraw a plea of not guilty and enter plea of guilty and plea agreement and disclosure itself. It also states, the defendant requests that the court accept his plea of guilty in reliance upon defendant's statements made in this motion and impose sentence accordingly. If Elizalde made his guilty plea based on an unwritten promise that the felony would be reduced to a misdemeanor, this would contradict those statements. In such a case, the plea agreement would not reflect the true terms under which Elizalde pled guilty, and the signed document would misrepresent the agreement to both the public and the court, creating the appearance of a felony conviction, while the true intent was for a misdemeanor. How could Elizalde have known with certainty that the felony would be reduced at sentencing and thus have been willing to plead guilty to a felony unless the judge had agreed to it beforehand? Did the existing relationship between prosecutor Vicki Becker and Judge Teresa Cataldo, who previously worked together in the same prosecutor's office and share a personal connection, combined with public perceptions of the well-known defendants, influenced the decisions surrounding the plea deal and the process that ultimately resulted in a misdemeanor conviction. The plea deal had significant legal implications. Under Indiana law, a felony conviction or a guilty plea entered at a felony plea hearing results in the immediate removal of a public officer from office by operation of law. However, if the felony is unrelated to their official duties, reducing the charge to a misdemeanor allows the individual to remain in office for the rest of their term, though they are barred from seeking re-election or holding any other public office in Indiana in the future. By reducing the charges, the prosecutor and the court allowed these defendants to continue representing the community and managing the public school system. School board members are expected to uphold the values and best interests of the community by modeling honesty and accountability for students and families. When officials with compromised integrity remain in positions of power, it not only sends the wrong message to students, but also undermines the credibility of the institution. How seriously should this be taken? Did the board members really just make a mistake? Kaufman, as we saw previously, argued that the candidates knew he was not the true source of the funds, and we saw the email from Kaufman on October 18, 2022, telling the board members that he was working on raising the money but couldn't do it alone. But what about the board members themselves? What did they say? Nafziger, Garber, and Johnson were questioned by City Councilman Doug Nisley at the West Goshen Neighborhood Association Candidate Forum on October 31st, 2022, 2 days after the mailer was sent out, and the same day Kaufman gave them checks to pay for it. Nisley asked why the mailer was funded by what he had heard was 2 people, and why he'd heard the teachers' union was approached to solicit funds for it. Andrea nodded yes, in reference to 2 people paying for it, but Nafziger interrupted and responded, "It was paid for either by us individually or by our campaign funds. And we will disclose by 12/31, as everyone here is required to do, we will disclose by the end of the year where the money came from and where it went. All receipts and disbursements on our campaign funds. I am going to pay for my share of that mailer from my campaign funds, and it came from a number of sources. Completely above board, completely legitimate, following the law, everything is recorded. It was paid for by the candidates and by our campaign funds. Where that money came from was from a variety of donors." Later, Glick interviewed Nafziger and asked why he claimed at the WGNA meeting that the funds came from a variety of donors, but then recorded all of them as coming from Kaufman. He replied, "Well, and Alan had said that. Yeah, Alan had said it was, yep, he was collecting the money, but that it was all coming through him. And Alan, when I talked to him, Alan said, and I don't know if he consulted an attorney, but he said, as he understands election law, since the money was all coming from him, it was still legal." Nafziger filed his form, which he pled was fraudulent, on November 2nd, 3 days after that event, knowing full well that Kaufman was not the donor. Glick also questioned Garber about the funding, to which he replied on November 4, 2022, "My understanding is that a large number of retired teachers and others donated to the cause. Someone collected the donations and gave them to Alan, and he distributed among the candidates." He filed his form on November 7th, 2022, 3 days later, and a full week after the WGNA meeting. Elizalde admitted to the election board under oath his knowledge of the fundraiser. The others tried to hide their knowledge from the election board. The Goshen News reported on April 14th, 2023, of the candidates in question, Jose Elizalde was the only one who claimed any knowledge of any of the circumstances surrounding the possible campaign finance violations early on. He was the only candidate who told the election board that he did know the funds were being raised by an outside source. The board members' own words and actions reveal a clear understanding of the true source of their campaign funding and a coordinated effort between themselves and Kaufman to conceal this information from the public and the election board. This deliberate deception, coupled with their subsequent filing of false reports, demonstrates an intent to mislead the community about who was backing their campaigns. Such behavior not only breaches legal requirements, but also betrays the trust of the electorate, casting serious doubts on their integrity and fitness to serve in public office. This concludes Part 5. In part 6, we will jump further into the legal issues and implications they have for the Goshen School Board. Come back next time for more details on the infamous 2022 Goshen School Board election. Have a good evening, and thank you for tuning in to this episode of the Shining Light Podcast.